My name is Mark Caldwell, and I'm here today to discuss deferred dispositions. People may wonder, what is a deferred disposition? It is where you have a charge and then you do a term of probation, and if you're successful on that probation, the charge will go away like it did not happen. It still will appear on your non-public record. It will not appear on your public record. What agencies who has non-public records of this? It would be law enforcement, judges, and certain government offices. Now, the first deferred disposition would be the Home's Youthful Training Act, which is also known as HIDA. That is a disposition for people that are between the ages of 17 and 26. If the individual is over 21 years old, it requires approval from the prosecutor. If they are under 21, it requires approval just from the judge. So if you're over 21, it requires approval from both the judge and the prosecutor. With the deferred disposition, there are certain crimes that are not going to be eligible for that. That would be traffic offenses such as your OWIs, would be any major controlled substance offenses, most criminal sexual conduct offenses, and offenses where the maximum imprisonment could be up to life in prison. When you are sentenced under HIDA, typically there's around 12 months of probation. You have to do community service, you have to do counseling, which could be drug and alcohol counseling, as well as paying off your fines and costs. And you have to do all of this successfully, and then once you do it successfully, the charge comes off your public record. If you're unable to do it successfully, it will result in a violation of your probation. And usually when you violate on your probation, you lose your HIDA status. Would be drinking while on probation, because a typical condition of probation is that you not use drugs or alcohol. The second deferred disposition would be a domestic violence disposition. That would be under the 769-4A statute. So domestic violence is any offense that occurs with an assault in a home. So it would be all residents of a home would be umbrellaed under the domestic violence. This could be your wife or your husband or children. Anyone that resides in the home would be charged with domestic violence. With the domestic violence, it needs approval from the prosecutor and the judge. It does not require approval from the victim. However, if the victim is unwilling to approve it, generally the prosecutor is not going to offer it. They're going to defer to whatever the victim wants. The third deferred disposition would be under the controlled substance. That would be use and possession of a controlled substance, and that would be under MCLA 7411-7411. With the controlled substance deferred disposition, typically it would be 12 months of probation. You have to do drugs and alcohol counseling. You'd have fines and costs, community service, and again, you would have to successfully complete all that, which if you don't complete, you'll lose your 7411 status and the charge will go on your record. Another benefit of the 7411 status is if you're charged with the use or possession of controlled substance, such as cocaine or heroin or any analogs like ecstasy, you will have license sanctions, which would, on your first offense, be a 30-day hard suspension and then a 5-month restricted license. If you get the 7411 diversion, you will not have those license sanctions. The last deferred disposition would be under 771.1. This one is the one least used by courts, but it allows a judge the discretion to delay a sentence and then after a term of probation, dismiss the charges. And the reason why you want deferred disposition is so that when you go to get a job and you have to put down, do I have a criminal offense? You can check the box, no, you do not, because it won't show up on a public criminal background case search. If you have any questions, give me a call, text me. My name is Mark Caldwell. My phone number is 616-915-6576. My email is mark@markmcaldwell.com.